Nobody saw this one coming in the form it arrived. Not the gun rights groups who had been fighting red flag laws for years. Not the states who enacted them. Not the law enforcement agencies that executed tens of thousands of orders under them. Supreme Court issued a 6-3 emergency ruling in 2026 Thompson versus Colorado, holding that red flag laws, also called extreme risk protection orders. By the end of this video, you will know how it violates both the Second Amendment and the Due Process Clause of the 14th Amendment simultaneously. So let's get into it. The ruling is immediate. The ruling is nationwide. Because this ruling does not merely stop future red flag orders, it retroactively calls into question every ERPO executed in America, every firearm seized under a red flag law in every state that has one, every person who had guns taken without committing any crime. The court just said that entire system was unconstitutional from the start. Subscribe right now, because if you or anyone you know has ever had firearms seized under a red flag order, what I am about to explain could mean you are owed those firearms back, owed monetary damages, and owed a formal legal remedy courts must now provide. David Thompson was a Colorado veteran and firearms instructor who had a red flag order filed against him by an estranged family member following a heated estate dispute. Thompson had no criminal history, no history of violence, no mental health adjudications, no prior law enforcement contact. Under Colorado's ERPO law, a judge granted the order in a brief ex parte hearing. Thompson was not present, not notified, had no opportunity to challenge the evidence. Police arrived and seized 11 firearms. Thompson challenged the order as a Second Amendment and due process violation. He lost in Colorado courts and the 10th Circuit. Supreme Court reversed 6-3. Let me explain the two constitutional violations the court identified, why all red flag laws share these defects, what happens to the 19 states with these laws right now, and what every affected gun owner must do. Number 1. The two constitutional violations that destroyed red flag laws. The Second Amendment problem. Justice Gorsuch, writing for the majority, applied Bruin's historical tradition test and found red flag laws without any founding-era parallel. Colonial and early republic law had mechanisms for dangerous individuals, surety laws requiring persons credibly threatening violence to post bond, and going-armed laws allowing disarming people actively menacing others. But these historical mechanisms shared two features. Modern red flag laws completely lack. First, they required a specific, imminent threat, not generalized risk assessment based on third-party speculation. Second, they operated only after the individual appeared before a magistrate and contested the allegation. Modern ERPOs flip both requirements. They allow firearm seizure based on predicted future risk, rather than imminent identified threat, and execute seizure before the subject has any opportunity to be heard. Gorsuch wrote, "History does not support disarming citizens on the basis of predictions about what they might do. It supports disarming citizens who have already demonstrated a specific, identifiable, immediate danger. Extreme risk protection orders, as constructed in every state that enacted them, fall outside this historical tradition." The due process problem. The 5th and 14th Amendments guarantee no person shall be deprived of property without due process. Firearms are property. When deprivation involves both property and exercise of a constitutional right, the required process is heightened. An ex parte hearing where the subject is absent, unrepresented, unable to cross-examine the petitioner, and unable to present counter-evidence fails this heightened standard. Gorsuch wrote, "We hold that a state may not deprive a citizen of Second Amendment rights, even briefly, without providing notice, opportunity to be heard, representation by counsel, ability to confront their accuser, and neutral adjudication before the deprivation occurs. The sequence states adopted, seize now, hear later is constitutionally inverted." Why 6-3? Liberal dissenters, Sotomayor, Kagan, Jackson, argued the majority applied too rigid a historical test and ignored founding-era evidence permitting preventive disarmament in some circumstances. Sotomayor warned the ruling eliminates the only tool available for rapid intervention in crisis situations, a serious argument that defines the limits of preventive gun law for a generation. Number 2. Which states are affected and what happens to their laws? The 19 states struck down. Every ERPO law is immediately unconstitutional and unenforceable. as of June 8, 2026. Pending ERPO petitions must be dismissed. Active ERPO orders are void. Law enforcement cannot execute new seizures. The retroactivity question, the part that shocks everyone. Thompson does not explicitly address retroactivity. The court deliberately left this to lower courts. Whether persons who had firearms seized under now unconstitutional ERPOs are entitled to return of property, damages, or other remedies will be litigated in hundreds of courts simultaneously. Gun rights organizations are already filing class actions in every state with these laws. Legal consensus based on standard constitutional retroactivity doctrine is that the ruling applies to all cases not yet final, anyone currently subject to an ERPO, anyone pending appeal, and possibly anyone whose ERPO was issued within the applicable statute of limitations for civil rights claims. Federal law untouched. Thompson addressed state ERPO laws. Federal law has no red flag statute. Congress has considered but not passed federal ERPO legislation. The ruling does not affect federal operations, though its reasoning would apply to any future federal ERPO statute. Number 3. What happens to seized firearms right now? Active ERPOs are void. If you are currently subject to an active ERPO in any of the 19 states, that order is constitutionally void as of June 8, 2026. The order cannot be enforced. However, this does not mean law enforcement will automatically return firearms. You must take affirmative steps. Demand return in writing. Contact the law enforcement agency that executed the seizure with a written demand for return of your property. Cite Thompson v. Colorado, June 8, 2026. State the ERPO is unconstitutional and void, and demand immediate return of all seized property. Keep a copy. File in federal court if refused. If law enforcement refuses, file a federal civil rights lawsuit under 42 U.S.C. Section 1983 claiming Second Amendment violation, 14th Amendment due process violation, and conversion of property. Seek return of all firearms, monetary damages, and attorney's fees under Section 1988. Damages for past seizures. Even if your ERPO expired and firearms were returned, you may have a damages claim for the period you were unconstitutionally deprived of rights. Statute of limitations for Section 1983 is typically 2 to 4 years, depending on state. If your ERPO falls within that window, consult a civil rights attorney immediately. Destroyed or damaged firearms. If law enforcement damaged or destroyed firearms during storage, you have a property damages claim in addition to constitutional claims. Document and photograph all damage upon return of firearms. Number 4. What states can and cannot do going forward? What states cannot do? Enact new ERPO laws with ex parte hearings. Execute firearm seizures before the subject has notice and opportunity to be heard. Use predictive risk assessments as the basis for seizure. Require subjects to prove they are not dangerous. What states can still do? Apply for firearm restriction orders following notice and an adversarial hearing where both sides present evidence. Use existing civil commitment for individuals posing genuine imminent danger. Apply for criminal charges when someone has made specific credible threats. Use surety bond requirements historically approved for potentially dangerous individuals. Constitutional replacement systems being drafted. Several states are rushing to create replacement legislation meeting the Thompson due process standard. 48-hour emergency notice to subject, hearing within 72 hours of filing with both sides present, appointed counsel for indigent subjects, clear and convincing evidence of specific imminent threat, initial orders limited to 7 days pending a full adversarial hearing. Whether these survive constitutional challenge is an open question heading to circuit courts. Number 5. Your action plan if you have been affected by a red flag order. If you currently have an active ERPO, contact a civil rights attorney today. File for emergency dissolution of the order in state court citing Thompson v. Colorado. Simultaneously send written demand to the law enforcement agency holding your firearms. Do not wait for the state to act on its own. The burden is on you to assert your rights under this ruling. If your ERPO expired and firearms were returned, consult a civil rights attorney about damages claims. Calculate the period during which you were deprived of your rights. Document all costs, legal fees you paid challenging the original order, storage fees you may have paid, cost of replacement firearms if you purchase substitutes, income lost if your firearms were work-related tools, and non-economic damages for the constitutional violation itself. If you were denied employment, licenses, or other rights based on an ERPO, some states report ERPO history to employer background check systems or professional licensing boards. If an ERPO that is now void caused collateral consequences, consult an attorney about remediation of records and potential claims against the state for those consequences. If you know someone currently dealing with an ERPO, share this information immediately. The ruling is June 8, 2026. The case is Thompson versus Colorado. Every person subject to an active ERPO needs to know their order is void and needs to take immediate steps to assert that right. Join the class actions. FPC, SAF, and GOA are coordinating class actions in all 19 states on behalf of persons whose firearms were seized under now unconstitutional ERPOs. Visit fpclaw.org, saf.org, and gunhonors.org. Register your interest. Your participation strengthens the class and potentially increases the damages pool for all affected gun owners. Bottom line. Thompson versus Colorado, June 8, 2026. 6-3. Red flag laws in 19 states unconstitutional on two simultaneous grounds. Second Amendment violation because ex parte preventive seizures lack historical foundation, and due process violation because seizing constitutional rights before the subject has notice, and hearing inverts the constitutional sequence. Ruling is immediate and nationwide. The 19 states, California, Colorado, Connecticut, Delaware, Florida, Hawaii, Illinois, Indiana, Maryland, Massachusetts, Michigan, Minnesota, Nevada, New Jersey, New Mexico, New York, Oregon, Rhode Island, Vermont, Virginia, Washington. ERPOs void. Pending orders dismissed. Seizures cannot proceed. Retroactivity, not explicitly decided. Lower courts will determine who is entitled to return of property, damages, and other remedies. Gun rights organizations filing class actions now in all 19 states. Anyone with ERPO within civil rights statute of limitations should consult attorney immediately. What states can still do? Post-hearing firearm restriction orders with notice, adversarial hearing, appointed counsel, clear evidence standard, civil commitment for genuine emergencies, criminal charges for specific credible threats. Action plan. If active ERPO, move immediately in state court and demand return of firearms. If expired ERPO, evaluate damages claim. Join class actions at FPC, SAF, GOA. Share with anyone currently under ERPO. Subscribe because Thompson versus Colorado will generate litigation in all 19 states simultaneously, and every development in that litigation directly affects whether affected gun owners get their property and their rights back.